Firstly, thank you for organizers for this such a wonderful opportunity, and it's my pleasure, and I'm so happy to be with you to share some information and my brief presentation. Maybe I will just orally talking about some summarizing on the application of fundamental rights at the EU level. So from the beginning, I would like to highlight that the European Union, as it's so well known fact that European Union is founded on the values of human rights, human dignity, freedom, democracy, rule of law. At the same time, is bound by the European Charter of Fundamental Rights, and at the same time is committed to European Convention for Protection of Human Rights and Fundamental Freedom. In this regard, some effect of fundamental rights in general private law, also in particularly in contract law, has been subjected by academic community, and I think the core issue question is that posted by and the case is that the public of law or autonomy of parties and freedom of contract on the one hand, on the other hand, that to see the protection of values which is recognized as a fundamental in society. So I would like to highlight from the beginning what exactly means fundamental rights at the EU level. So as we know that basically fundamental rights refers to all to core rights and freedoms that are safeguarded by national constitution and plus international human rights treaties. And here maybe the core principles for applying for defining the fundamental rights is codification at the constitutional catalog of the fundamental rights. And according to case law at the EU level, for example, if we see the Netherlands or German law, I can say the fundamental rights there is a part of the positive law, and which is also has been broadly formulated by the part of the constitution and the international treaties, plus as a part of the European Convention for Protection of Human Fundamental Rights plus fundamental freedoms. And it's totally another example if we see the British law, but after the Brexit, as you know, that British will be not anymore the member of European Union, but in any way, I just put some examples from the British law also. So according to the common law, the fundamental rights can, it's not necessary, has been written down in the written way. It can be also instead of the fundamental rights. So, but they have own Human Rights Act, and they have own definition and broadly, which is include also personal security, personal freedom, rights to private property or rights to association and etc. also. And the core yes, and after defining, I would highlight some effects like direct and indirect effect on to the fundamental rights in the contract relationship. Since, for example, the direct effect was introduced in Germany, so it means that parties in civil law, in private law, I'm sorry, they have the same effect like relationship between the state and citizenship. So it means that fundamental rights would be developed in directly binding provisions. So and have direct applicable. But according to the indirect effects that fundamental rights, I mean the private parties, they are not addresses of the fundamental rights, and they cannot be bounded by these rights. So it's more about interpretation of the general clause. And the core issue that in private law that one of the most discussed aspects maybe of a possible impact of fundamental rights in contract law is that whether these rights should be given direct or indirect effect. And since relationship between citizens are essentially between citizens, I mean between the private parts are totally different than the relationship between state and citizens. So I can say that fundamental rights have been designed, as we know, that have been designed for protection of public interest, but it cannot be applied in the same way in the contract law also, since we have since it's conflict with the freedom of contract and as I said before, autonomy of the parties also. But we have some general clause in private law, especially in contract law, for example, just they have some possibility to resolve the case between the general clause, like what it means, good moral or good faith, when as a principle, let's say as a principle, when they don't have exactly rules on the contract. So in conclusion, just I would like to highlight that theoretical framework does not provide clear guidelines for establishing of the impact of the fundamental rights in contract law. The reason that direct indirect effect distinction cannot clarify the relationship between the constitutional law and the contract law. So yeah, someone who consider constitutional law to be superior than the contract law, and some scholars, for example, some scholars, they see that seeks to reserve autonomy of the contract law will prefer it than indirect manner of giving effect of these rights. So, there are some steps for DCFI, like draft common frame of reference, which is also included fundamental rights and non-discrimination in private law relationships. So we have some positive, let's say, step in this way also. Just in briefly, I just would like to say this, and I'm so sorry that I missed this. Since I'm outside of Hungary and I'm in home country, this is some difference between time zone, etc. So thank you for your pay attention.